Hello, everyone, and welcome to the Hodlcast. Today is October 5th, and it's kind of a day to remember from Mr. McAfee anyway. He just was arrested, one of my former guests, on some, I guess, ICO, pump and dump charges from the SEC and also for tax evasion. So I heard he was arrested a few hours ago in Spain, and I'm sure he'll make some friends in the jail, and hopefully, get it all sorted out fairly soon. Today we're going to talk about the New York Bit license as it applies to BTM or Bitcoin ATM kiosks that are located in places outside of New York. I recently had a client ask me this question. They were advised by their compliance officer that they need to block every New York resident that goes up to their machine with a New York driver's license. And, that seemed like a pretty big overreach of New York's power. But when I read the bit license, it actually is how it's written in the license. So, we're just going to go through basically all the reasons why that's an unconstitutional overreach on behalf of New York. So, first of all, I guess we're need to state not aware. I've never heard of a case. So if one exists and I missed it, that's pretty bad on my part. But I don't think New York has exerted the bit license law on any transactions that are conducted by New York residents while they're located outside of the state, meaning like outside New York, outside the country, outside, on a federally established tribal reservation. If they're going to say they have jurisdiction on their residents when the residents are outside New York, not only does that apply to New Jersey, it also applies to when that customer is traveling to Australia, the way it would be written. So that's, that's a pretty long arm they think they have if they really were to try and apply it in that fashion. And then, there's also some significant obstacles for a state to try and assert its law on any other kind of out-of-state activities. And that's, if we look at, I'm from Canada, so, the first thing I can think of that would be, common sense comparison here is in Canada, the drinking age in Quebec, or the age to buy cigarettes too, is 18, whereas the rest of the country it's 19, or most of the rest of the country. And so people can legally go, drink at age 18 in Quebec, and they're not expected to follow the rules of their home province. And it's the same thing you can think of in America when someone's, I don't know about the tobacco ages here, but if you think about it, for purchasing marijuana in certain states like Colorado or Nevada, anyone can go up to a store. They don't block people whose states say, oh, these people can't have it in our state. Doesn't mean that applies when they go to the store in the other state. And you can think of it also like driving on a highway. If your state has a speed limit of 60 and the neighboring state has a speed limit of 70, and are you expected to drive 60 all the time when you're in the other state just because your home state says that's as fast as you can go there? So when you really think about it, it's kind of silly to even imagine that this law would be upheld in other states. But, we need to go through all the rigmarole to make sure we're giving people the right advice. And, as always, a podcast is not legal advice. This is just my opinion. So the other, things to look at with this is how could New York practically extend this law? Like, how would this really work? So if New York actually expected businesses in other states to investigate and verify the residence of each customer initiating a transaction, and then turn away those customers that are from New York, you know, they'd have to define what New York residence really means in a definitive manner. Like, how many days do you have to live there to be a New York resident? How many days can you be traveling before you lose your New York residency? And, you know, at the current time, no such mechanism exists. And then, so the actual wording of the bit license is that, you know, virtual currency business activity. That's the activity that they're regulating, virtual currency business. And it means any one of the following types of activities involving New York or a New York resident. And that's one, receiving virtual currency or transmitting virtual currency, except where the transaction is undertaken for non-financial purposes and does not involve the transfer or more than just like a nominal virtual currency. Storing, holding, or maintaining custody or control of virtual currency on the behalf of others. Buying and selling virtual currency as a customer or a business. Performing exchange services as a customer or business. Or controlling, administrating, or issuing virtual currency. So under BitLicense law, a New York resident is defined as any person that resides, is located, has a place of business, or is conducting business in New York. So anyone that meets any of those categories, you know, no one can do virtual currency business with them. The term resides is not otherwise defined, and there's no clarification provided anywhere else under the BitLicense law. So we have to take the term in this context, like it just, you know, that it means everything that was just described. You know, whereas like an encyclopedia, so West Encyclopedia says that residence is defined as personal presence at some place of abode, although the domicile and residence of a person are usually in the same place, and the two terms are frequently used as if they have the same meaning, they're not synonymous. A person can have two places of residence, such as one in the city and one in the country, but only one domicile. So even right there, you know, we have the West Encyclopedia defining residence that you can have two. So if New York is trying to, you know, then what? Like if you have a home somewhere else, you know, which residence do you choose? You know, it's a pretty arbitrary. Obviously, you're going to choose the one not in New York, but anyway, so it's too vague. The definition is vague. It's difficult to understand in this regard, and thus it can reasonably be interpreted that BitLicense law is applying to people who are personally present at a place of abode in New York. That's, you know, what residence can be defined as. So then there's the word domicile, and that's like a more specific term, and it could be interpreted to mean that the legislator intended to regulate transactions with those who are presently in New York and not with those who are elsewhere, even if they are residents of New York at the time. So the topic of whether the law can apply to out-of-state businesses that are addressed in New York, it's answered by the New York Department of Financial Services in their question and answer. So the question specifically reads, is an out-of-state business required to obtain a bit license to engage in virtual currency business activity in New York State or with New York State residents? And the answer is yes, a business must obtain a bit license if it engages in virtual currency business activity involving New York State or any person that resides, is located, has a place of business, or is conducting business in New York State. So it's a little bit of a mouthful, but let's look at now, you know, at the constitutional analysis of this. So as a matter of U.S. constitutional law, one state is simply not permitted, even incidentally, to intrude upon the interstate commerce of the other state. Interstate commerce just means business. Like you can't think of it as like a, you know, a drug turf war. The Crips have one state, the Bloods have the other state. You can't go on to that other state and sell stuff or prohibit them from selling stuff. It's just the rules. So, you know, but people are always testing them, and it's a heavily litigated area. And when some things are heavily litigated, often case law can kind of spike into different factions depending on different states. And that's what we have in this choice of law on the state level. Like two states will get in a fight, you know, 50 years ago, and they'll determine a case, and then say it was Florida and Alabama having that fight. Well, then the same fight might happen between New York and Connecticut, but the judge up there determined it completely differently. And then the next case has to build off that previous law. So as you can imagine, we have like basically 50 different fragments of how this choice of law works between two states in their commercial turf wars, basically. But the Supreme Court is who is in charge, who they all must look to. So if someone doesn't know how to answer it, they can look to the Supreme Court. And here, the Supreme Court, kind of like for those who are familiar with securities laws, will recognize how the Howey test has been adopted as the main test that people look at to determine if something's an investment contract. Well, the Pike test is considered, you know, I don't know if it got as much weight as the Howey test or if it's as widely used, but it's a main test for determining this. And what it says is, where the state statute regulates even-handedly to effectuate a legitimate local public interest and its effects on interstate commerce are only incidental, it will be upheld unless the burden imposed on such commerce is clearly excessive in relation to the putative local benefits. Again, bit of a mouthful how they write these statutes, but the case developed basically what's become known as the Pike test that outlines the factors of undue burden on interstate commerce. And so those definitive principles for state statutes look at, you know, there has to be a legitimate interest, there has to be a public purpose. So here, you know, what is the legitimate interest? What is the public purpose of having the New York bit license extend to another state? And, you know, all these BTMs are regulated by FinCEN. So any state regulation is, you know, completely duplicative in nature to begin with. So there's a strong argument that none of the states have a legitimate public purpose to regulate these transactions. And most states don't. Most states, even if they do regulate Bitcoin at some level of money transmission, they recognize that a Bitcoin ATM transaction is unique in nature in the fact that it has two people, not three. So it often avoids the need for money transmission licenses, even in states where something like operating a Bitcoin exchange might involve. That they don't look at the custody of it. That's a whole nother beast. But basically, New York is one of the only places, there's about 10 actually, where BTM transactions are regulated, but New York's, you know, one of them. And so extending that, you know, legitimate purpose that barely exists or, you know, arguably doesn't exist in the state, but trying to extend that to another state is really, really a far stretch. And then to say that it has a public purpose. You know, that argument has been made by Bitwise last year when they were going for their ETF. They were able to show some pretty strong numerical proof that all the companies that were regulated by the New York Bit License had a much higher track record for honesty in their transactions. There was a lot less wash trading, and you know, there were more respectable exchanges. But you know, those exchanges people are required to act with that level of integrity by the federal regulations. Not everyone is registered on the federal level, even if they should be, especially come exchanges that are, you know, not American in their domicile. They often don't register with FinCEN, and so, you know, it could be argued that the New York states are also all the US-based exchanges. So they would operate with that level of integrity because of the federal law, which applies to them. Anyway, so we could have a big, long discussion on whether the statute is legitimate, whether it serves a public purpose. But it has to be in the state's power and not designated either to regulate interstate commerce as such or to be discriminative against out-of-state economic interests in favor of private in-state interests in the same market. So here, I don't think we see, like, it's not giving New York companies an advantage to have this license. Well, that could be argued too, because some people might say, actually, yeah, it makes them more trustworthy to have it, but that's the company's choice if they want to enter New York and get that. But they don't need it in other states, and it doesn't serve, it's not within New York's police power, really, to go after ATM providers in other states that are not, blocking New York. And then anyone that's a market participant or similar to like a private equity or has a dormant commerce cause, it can't be a bar to economic decisions, even if they impact or discriminate against interstate commerce. Though the Privilege and Immunities Clause, which is found in the Constitution, Article 4, it may also provide a constraint here. And then the effect on interstate commerce has to be incidental rather than the primary purpose of the statute. The interest must be local, the statute must regulate even-handedly, and the statute must effectuate its local public interest. So here, I think that's the strongest argument, is that it impedes Company A's ability to conduct business in states other than New York by requiring that Company A or, any BTM operator to either obtain an expensive and cumbersome bit license or make an effort. So they have to like actively hire someone to review their IDs and go through and block New York licenses from using the machine. So think about it. If someone goes up to a machine and scans their driver's license, there's not usually a way, like I guess the software could have AI on it where it picks up New York and then immediately blocks that transaction. But typically what happens is the person scans the license and it's stored by the machine, and then the compliance officer goes in afterwards. Either the person has already created an account and verified themselves, or they can only do a small transaction at the time in case they were putting some fake ID up or something like that, right? So the machine, without having someone verify the person, so you have to then hire a compliance officer and pay them their hourly rate to go through and look at every person that's gone to the machine and say, is that one from New York? Is that one from New York? If so, they can't have an account with us to use the machine again in an amount over, say, $500. And then what if that person might be, an amazing customer and the ATM is set to make 20% on every transaction. Usually they do make 10 to 20%. So, that's giving up a big business opportunity if they have to block every New York person, especially considering there are not, as far as I know, a lot of opportunity for New York people to use Bitcoin ATMs in their own home state. So often they do have to leave the state. So if someone has one nearby, they can access the whole New York population. It would be a huge disadvantage to have to block them. So the interest is not local. It imposes a pattern of multiple inconsistent burdens on other states, and it imposes conflicting laws on the company, the Bitcoin ATM company and interstate enterprise. So, then we get into the choice of law analysis test. And the first one, there's a few different ways that courts have looked at this. The first one is the significant contacts test, and I think this should just be the only test we really need to look at. It's the most common sense one, but it says that a contract is governed by law of the state where it is made, and that a contract is deemed made in a state where the last act necessary to make it a binding agreement occurs. So if you're thinking of a Bitcoin ATM, I mean, the whole contract really takes place the person walks up to the machine offers, like that's the offer of the contract, that you can put money in. And by accepting the money, that's like acceptance that it's gonna, you know, fulfill its contract by sending the customer Bitcoin. The customer takes the Bitcoin and walks away, and the contract is over. And so, you know, the whole thing is short and local in nature. It's not like you're sending an email contract on paper, you know, over the internet. So two people are in two different states. When the machine is the one that you're contracting with and it's located there, you know, that's the full extent that you need to really look at for this answer. But anyway, law is such that you have to analyze it on every different level. So basically, you know, it's this significant context test says so clearly that a binding agreement is occurring, you know, where the kiosk is located. Then you have the restatement second of conflicts of law. So what the restatements are is basically a group of states will get together and say, we would like to have a streamlined state law for this topic. And then, you know, they write it as, you know, clear and concise and all encompassing. And, you know, they're just some really expert writers get together and make this the law. And then each state can, as the judge is writing the opinion, they can basically pull in the restatement second or restatement third, whatever, you know, they get updated every 20 or 30 years. But so a lot of states use this. And it says, I'm not going to read it. It's, you know, kind of long, but basically, in the absence, so you can write your law into your contract if you have a written contract. Like, say we really wanted to take advantage of Wyoming's Bitcoin property laws that put it into the UCC status, the Uniform Commercial Code, as property rather than basically they try and make utility tokens immune from SEC regulation by saying it's property, but people can access that law by writing it into their contract, even if neither party is in Wyoming, or say one company is registered in Wyoming, the other party is in Florida. They can choose to follow Wyoming's laws on it. Whereas here they're saying, so if no one did that in this case, which, you know, a BTM operator could try and do that in their terms of service, but I don't think it would hold up. I think the actual fact that they're located in the certain state is going to actually trump the terms of service. But don't quote me on that. I don't know. But the factors that they give on the second part of the restatement says, in the absence of an effective choice of law by the parties, meaning like that they didn't put it in their terms of service or write it into their contract, the contracts to be taken into account in applying the principles are to determine the law applicable to an issue include A, the place of contracting, so that's the most important. B, well, the factors. The place of negotiating the contract in a Bitcoin ATM transaction, that's also, you're negotiating it when you're doing it. Like, there's no pre-negotiation of this. The place of performance, so, you know, where you get the money out of the kiosk is going to be your place of performance, again, the location. And D, the location of the subject matter of the contract, so again, the location of the BTM. And E, the domicile, residence, nationality, place of incorporation, and place of business of the parties. So, you know, that does matter. If, say, the Bitcoin ATM company is domiciled in New York, but they place the machine outside of New York, and then a New York resident also goes up to the machine, but it's outside of New York, you're going to have two factors. It's like basically two New York residents are contracting. So does the bit license apply? Well, actually, the other four factors that all say that the location where it's happening is more important than that. So, and then if the place of negotiating the contract and the place of performance are in the same state, the local law of that state is usually applied. So if you can combine two of these together, which in the BTM transaction, we've got all 4 out of 5. Pretty much you're looking at the law of the state. Then there is the lex loci test. And so this says, when 2 conflicting state laws are in conflict, a form determination is necessary, and the strongest test is the lex loci test, which means the law of the state applies based on the location of the transaction or the occurrence that gave rise to the litigation in the first place. And the state where the transaction takes place retains plenary power to make the laws covering anything that is not preempted by the federal Constitution, federal statutes, or international treaties ratified by the federal Senate. So that is just basically saying that each state is free to make their own laws as long as there's not a conflicting federal law, which on Bitcoin ATM transactions, we know, yes, the Bank Secrecy Act is overarching all of this. But that, we're talking about the state law here, but when we just know that the BSA is also going to trump any state law. So then the lack of available compliance mechanisms here. So if New York actually intended to require that a business in another state determine residency of each customer, initiating a transaction and then refusing to conduct business with New York residents to meet constitutional standards, New York would first have to really provide a clear definition of the word resident. And, we talked about this a little bit earlier, but it's not good enough right now, the way they've got it written. It's too vague, it's difficult to understand, and they need a really clear definition of that if they think they're going to apply it. So yeah, in conclusion here, basically a company can engage in transactions with New York residents as long as the transaction is taking place at a Bitcoin ATM kiosk that's not located in New York. And they must comply with the law of whatever state that the kiosk is located in. So yeah, that's it for today. I hope everyone's doing well, staying healthy, keeping the vitamin C going, and until next time, have a good one. Thanks. Bye.